Good afternoon to those of you in Washington, D.C. Good morning to those of you on the West Coast, and hello to everyone who's joining us on the webinar from across the country today. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. Welcome to our program today entitled Managing Your Nonprofit's Facebook, Twitter, and LinkedIn Presence, Avoiding the Legal Pitfalls. First off, I want to give a special appreciation to one of our panelists to hear Krista Coons from our New York office, who woke up this morning to the terrible news about the Amtrak tragedy outside of Philadelphia. Was supposed to take the Amtrak train down here to D.C. today. And she went through heroic efforts to find her way onto a plane and make it here in time for the program. So we very much do appreciate that. And our condolences do go out to all of the families of the victims of that terrible crash outside of my hometown of Philadelphia. We do have what I think is going to be a terrific program here today, and apparently a lot of other people think it's terrific too, because we actually have the largest number of registrants we've ever had for one of these monthly programs. We've been doing these for about 4 years now. We have over 600 people signed up for today's program. We have a full house here in D.C., and I think about 500 people registered on the webinar across the country. So hopefully we will not disappoint today. No pressure, AJ and Krista. Few housekeeping notes. First off, for those of you from the Trade and Professional Association world, these monthly programs that we do are eligible for CAE continuing education credit. Preview of our scheduled upcoming programs. As always, we try to cover a diverse array of topics that affect the nonprofit legal world. Next month on June 4th, our program entitled Top Trends and Traps in Nonprofit Executive Compensation is actually being co-sponsored by GuideStar. So unfortunately, AJ, that is likely going to easily break the record of today's attendance. Usually when GuideStar gets involved and their massive 125,000 person nonprofit mailing list, we'll probably easily break the 4-digit mark on registrants for that one, so sorry. But you'll hold the record for a month at least. AJ Zatola to my far right is probably done more of these nonprofit legal programs with us than any other Venable lawyer. And he was very proud to have the record attendance today, so you get it for about 30 days or less. On July, and that's going to be a terrific program with one of our lawyers and 2 outside experts who are real knowledgeable and expert in the field. I think it's going to be a wonderful program for all nonprofits of all categories of tax exemption. On July 15th, our program will be entitled Mental Health Issues in the Nonprofit Workplace, Questions Raised by the German Wings Air Disaster. A couple of our colleagues, one of whom is here with us today, Doug Mishkin and Ron Taylor, are going to be leading that program on July 15th. A very interesting one, and those of you who come to our programs know we always try to devote usually 2 of our programs each year to employment-related issues affecting nonprofit organizations, because they always tend to be incredibly important, very interesting, and of great interest to our audience, and this one should be no exception. And then on August 6th, another topic that always seems to be incredibly popular anytime we do anything relating to nonprofit meeting contracts, hotels, convention centers, meeting vendors, and anything else relating to meetings, of which virtually all nonprofits are involved. We always tend to get a lot of interest and a lot of participants. Our program on August 6th, Top 10 Must-Have Provisions for Nonprofit Meeting Contracts, is one that I hope you'll attend. And despite the fact that it is in August and is in D.C., we do tend to usually get still good participation for those as well, so hope you can join us. As always, all of our programs are recorded and hosted on our nonprofit YouTube channel. So any programs that you ever missed, you can feel free to go back and watch and listen to those at any time. The link to that index of all of those recordings is on the last page of today's PowerPoint presentation. Those of you in D.C. have a handout booklet that contains hard copies of the PowerPoint slides along with full speaker bios, as well as a number of additional handout materials, articles that AJ and Krista and myself and others have written here at Venable on all of these social media related legal topics. It's really quite a number of valuable articles in the back of the handout materials that I'd encourage you to take a look at. Those of you on the webinar were emailed the PowerPoint slides, but tomorrow all of you will receive an email with a link to the recording of today's program, along with the PowerPoint slides and all of those handout materials. And what we will also do is include links to the prior recorded webinars that we've done on social media related legal topics for nonprofits. We've done two or three that are very relevant. And today's program is really going to kind of go beyond those and touch a little bit on some of those basics, but really go more in depth into the specific issues that we're going to focus on today. Those may be helpful background for you. Feel free to share that email with colleagues and others who may benefit from those. In terms of questions today, we don't have an incredibly packed PowerPoint deck because we do anticipate a lot of discussion amongst the speakers and questions from you guys. We always seem to get a lot of questions on social media related topics, always very interesting ones. So feel free to ask your questions. I'll prompt you at several points along the way for questions, and when we hit kind of logical breaking points. Those of you in the room, please wait for the microphones to come around. Just raise your hand when you want to ask a question, and someone will bring a handheld microphone to you so everyone on the webinar can hear your questions. Those of you in the webcast, please pose your questions to me using the chat feature on the webcast software, and I'll pose those to our questions at the appropriate times. In terms of our speakers today, to my far right is AJ Zatola. AJ is a partner with whom I've worked for virtually my whole 16 years here at Venable. AJ is one of our absolute key go-to people when it comes to anything related to social media, websites, copyright and trademark issues, technology transactions, and kind of everything in between. AJ has a terrific technology background himself, understands intellectual property and all of the other related issues that go along with this world. But because he works with and has worked with literally hundreds of our nonprofit clients over the years, he really has a great understanding of how these issues play out in the nonprofit context, which I know you'll find very valuable here today. And to my immediate right is Krista Coons, an associate from our New York office who does basically the same kind of work that AJ does, and then they work closely together. And Krista also has worked with many of our nonprofit clients in this area. And again, thank you, Krista, for making the trek down here to DC today. Without any further ado, I will turn it over to AJ to get us started.
Welcome, everybody. We're going to roll right along. Usually I have a loud voice. Most people are not telling me to speak up, but in this case, we're going to roll right along through the slides, and when we do that, understand that the slides give you a little bit of basic information about the topics we're covering. This presentation, we're going to try and be a little bit more practical, very much focused on Facebook, Twitter, and LinkedIn. We're going to allow opportunities for questions and talk a little bit about some of these topics as they relate to those three platforms. We pick these three because they tend to be the platforms most commonly used by nonprofits. I'm not suggesting that all of you will use all three, or if you see utility with one versus the other. I mean, that's going to vary by strategy, but these do tend to be the most popular, with an exception. One of the slides we'll talk about today, we did highlight a little bit of the capabilities of Pinterest simply because we wanted to illustrate something for you to understand. And all of the other network operators offer something comparable to what Pinterest is doing, but most people might recognize the feature a little bit more easily with reference to Pinterest. So when you think about today's presentation, do try and think about what you are doing with respect to Twitter, LinkedIn, and Facebook. In terms of what we're going to cover some of the basics of why you're using social media, some of the basics of the things you ought to be considering in advance or in the background as a part of your social media usage. We're then going to talk a little bit about some of the considerations with using social media. What do you give up? In particular, what rights are you giving away to allow people to see content, etc.? And then we're going to talk about what you need to do to enforce your rights. And we're going to highlight quite a bit intellectual property, but in a couple instances I'm going to point out that we've used intellectual property procedures for other purposes. We've had a couple cases of late of phishing, which is basically one of your sites has an imposter site created. We have utilized the IP takedown processes to assist with those kind of events. So even though something might be labeled copyright or trademark, there are instances where you can use those steps to take care of some other event that's happening that might be impacting negatively your online presence. Finally, we'll talk about some of the other terms, how to manage your presence online or through your page. Some of these things are going to be considerations that kind of move in the direction of labor and employment a little bit. That's going to be a topic that's a little bit outside of this. I mean, everyone's labor and employment policies vary, but they do kind of go hand in hand with social media usage, because one of the main challenges with social media is you have a an online presence for your nonprofit, and then many of your employees using it for personal reasons. And trying to determine where that line is between the two can be a challenge. So, let's get into this. I'm not sure how people are using social media these days, but in terms of how most people are using it in a nonprofit sense, first and foremost, use it for promotion and advertising. That's usually the main reason to use it. It also is a way to sort of cultivate a brand in a more interactive way. It can be an opportunity to connect with people, so connecting with constituents, members, interested parties, very easily done through social media, and can be a very powerful platform because it does allow for a lot more communication on an instantaneous basis than you might see in other forums. Fundraising, recruiting, product sales possibly. To some extent, the sky's the limit on how you can use social media platforms, but these are the kind of things that we have been seeing a lot of nonprofits engaged in.
And I think you guys will all be familiar with this, but I think one of the motivations for this presentation and for one of the reasons for its popularity is probably that we are in sort of what I will loosely refer to as the post-IBC era, right? The post-Ice Bucket Challenge era. Everybody saw the traction that campaign gave, and I think it's really spurred a lot of additional activity, particularly from nonprofits and associations working for good causes and fundraising.
Excellent point, and we also won the law firm challenge for the Ice Bucket. I think we had 100 people pour ice on the heads. Okay, so what are your assets online? What are you most concerned about protecting? To a large extent, we're talking about intellectual property, okay? Some of you might be familiar with what intellectual property is or what it might be, but it's copyrights, trademarks, patents, and trade secrets. In terms of how these apply to an online setting, you can think of copyrights, which is protecting creative expression, as covering things like a video, an article, a report, a picture, a design. Trademarks, that's the name of your entity, the name of products or services you might offer. Some of you might even have things that sort of align with a type of certification or a diploma, so those are names, source identifiers. Patents identifies novel concepts. We're not going to really talk about them too much today because this presentation is not really geared towards development, but that is another form of IP. It can be a very powerful form of IP. And last but not least are trade secrets. And this is information that has value because it's not known. And in the online setting, particularly as it relates to your accounts, the most common type of trade secret you need to start thinking about are your contact lists. You will empower people to connect. They will establish connections. They will have addresses for those connections. Those can be very valuable assets, similar to a customer list. You need to start considering them as an asset that requires some protection and forethought. And so, a trade secret can certainly extend to your contact lists. It can also cover certain forms of communication if you are taking steps to maintain the confidentiality of that communication. So certainly it wouldn't apply to a message or communication that's broadcast. But if it was a private message and the private message had headings or indicators that this is a confidential information communication, that the information contained is confidential, then certainly trade secrets can extend to that kind of communication as well. And then last but not least, materials you plan to distribute can certainly qualify as trade secrets. But again, you need to be considering the act of distribution. How public will it be?
And while we're not going to have time in this program to get into the nuances of copyrights versus trademark versus trade secrets, a number of our prior programs that we're going to send out the recorded webinars for do cover those issues in great detail. It's really important to understand those because some of the same information, some of the same documents, some of the same logos, slogans, images can actually be subject to protection under multiple categories, of intellectual property. It's really critical to understand how they may be subject to protection under each or under neither, and what sort of things you need to do to maximize that protection, where you may not have protection. For instance, if you assume something is covered under copyright protection, like an alphabetized list of donors, for instance, and then you later find out, wait a second, that's not subject to copyright protection because it's not an original expression of a creative idea, the only way to protect it is potentially as a trade secret or through contract law, that's going to affect the way that you share or distribute or let others use that information, whether it's via social media or otherwise. So it's really important for you to get a good handle on these things. It's very difficult. There's a reference somewhere in the PowerPoint deck to the fact that people constantly confuse copyrights and trademarks. Happens all the time. Don't feel dumb if it happens to you, because it happens to so many people. But I cannot stress to you how important it is to get a good handle on those things, because doing so will be really important to then take everything else you learn in today's program, be able to act on it effectively.
So the first place we always start when we're confronting an issue that happened within a social media network is never answering the question that the client put forth. The client will be identifying a problem. Somebody's misusing this. This happened with our video. Somebody stole that. I can't get access to this. We don't answer that question first. What we do is ask the question of, do you actually own the property or item you're complaining about or bringing to our attention? That's step number one. Always should be step number one. We've probably talked about this in numerous past presentations, but it doesn't hurt to remind you again to think about ownership. So when you're thinking about ownership, you want to think about rights of ownership, both yours and others, as it applies to anything that might occur or be connected to your online accounts. So in terms of things that are created as a part of the account, so again, I made mention of the contact lists. That theoretically could be an item that you would claim ownership in. In terms of materials you might distribute, those are clearly items that you'd want to claim ownership in, or at least have the rights to use. In terms of things that are created as a part of your social media interaction, again, things that you might want to claim ownership over. It's very, very important to have rights to the things that you claim as your own property, or at least have considered who has rights. What can sometimes happen in social media context is because communication is so easy, it just naturally flows both directions, and you're not giving consideration to who owes what, or who owns what piece, or where you got it from. How often have you saw something interesting and decided to share it? Some of these platforms allow this, and we're going to talk a little bit about that, but have you ever given thought to whether or not you had the right to share it? What if someone takes something off of your page and shares it in another place? Is that something you're comfortable allowing? Did you even cover your rights to allow it in the first place? So ownership is the first place to start.
Yeah, maybe another way to think of it too is, I often think of intellectual property rights kind of in two buckets. One is securing the ownership and or the rights to use the material yourself, and yourself being the nonprofit organization. There may be others that have joint rights, as we'll talk about, but it's important for your nonprofit to, A, if you can, try to secure ownership of that intellectual property. Could be copyrights, could be trademarks, could be trade secrets, could be other things, and then or at least have sufficient rights to be able to use that intellectual property even if you don't own it. And then the second bucket is, okay, once you have those rights, then how are you going to let others use that intellectual property? Are you going to give them express permission? Are you going to give some kind of blanket license? What are the terms of their usage? When can that usage be revoked? How can others contribute and build on that intellectual property? All of this happens in the social media context. And it can be very confusing. Like AJ said, clients come to us, we're dealing with quite a number right now, where here's the issue, here's the problem. Someone's misusing our information, or someone's defaming us. It's all happening over social media. And we need to first kind of break it down and figure out, okay, who owns what, who has what rights, what risks do we have or not have, and then once we figure that out, then we have what rights do we have to enforce that ownership, et cetera, on social media, prevent others from doing something or not doing something. It's complicated and difficult, but you really need to kind of think about it in that way to kind of break it down if you want to make some smart decisions.
So in terms of who owns, very, very general rule as a place to start is to consider the idea that the author, the creators, or the inventor is the person or entity that owns. And always start there. Now, applying that thought or process to your nonprofits, I mean, if your employee is the author, inventor, creator, then the employer generally owns. The concept of work for hire, the concept of what rights an employer has, it will apply to a lot of intellectual property that's created by your employees. And you don't necessarily need to do anything to make that operative. However, you need to give thought to whether or not your employee was empowered by you as part of their employment duties to actually create IP. The classic example from the Good Will Hunting folks is your janitor creates some valuable IP, but you didn't hire the janitor to do that. That would not naturally fall within the scope of duties of a janitor, and so you can't necessarily assume that the employee's rights are automatically going to be the employer's rights. So even though, generally speaking, the employee's creations are going to be owned by the employer, you need to think about whether or not they're being created within the scope of duty. So give thought sometimes to whether or not everyone ought to have that creative power or process or role. So what do you do then if you don't naturally own it, but the employer or even a contractor created it? This is where you need to get it in writing. Many forms of IP, particularly copyrightable works or patents, require a written assignment, a written conveyance. This is a real estate concept that was brought into the intellectual property world. You got to get it in writing, and it has to say very basically, I assign to you. It can't just be a designation of ownership where the nonprofit was supposed to own, or everyone agrees that they're going to be the owner. It needs to show that a transfer occurred. The point of this exercise is to have a piece of paper to say that the title to the property is changing hands. So you will commonly see in a lot of agreements with your employees something to the effect of, this is work for hire, meaning automatically going to be owned by the employer. But if it's not, you're going to assign it to me. And in connection with this, again, think about what the employee is supposed to be doing, whether or not their role includes development. And don't assume, by the way, that just dropping in the words work for hire automatically is going to mean you own everything. It doesn't. It's a specific enumerated set of categories. So taking that thinking to the online world, it is in question right now whether or not a contact list qualifies as work for hire property. I can't really tell you if it does or doesn't. So things that an employee might be doing online in their own individual capacity might still belong to the employee. So if you're going to allow employees to be creating things through their social media accounts on behalf of your nonprofit, you need to give thought to whether or not those creations are covered by some agreement that makes clear the nonprofit owns. And chief among those things tends to be the contact list, but other types of communications or things that you might want to have control over might be another form of property to say in your agreements with your employees, if you create things for us online or through social media accounts, we're going to own that too as a part of the employment duties.
And AJ, just to clarify, for most nonprofits, as you know, don't have written employment contracts with their employees, usually with the CEO, not usually with anyone else beyond that. So we're not necessarily suggesting you need to enter into employment contracts. And as Doug Miskin and others can tell you, there are many good reasons why you don't want to enter into employment contracts, and there's good reason why most nonprofits don't have employment agreements with most of their employees. Most of you who work for nonprofits would probably love to have them, but your employers, frankly, aren't going to enter into them, and we wouldn't advise them to either. So don't take it the wrong way. We're not looking for that. We're usually talking to our employees about provisions in your employee handbook or something like that. What's really most important, I think, what AJ's getting at, is when we're talking about non-employees, paid contractors, volunteers. Two of the big lifebloods of content for a nonprofit organization. You constantly hire independent contractors to develop all sorts of content for you, graphics, websites, logos, anything else you might hire an independent contractor to do. It doesn't matter how much you pay them. It doesn't matter that you have a written contract to pay them and for them to provide services. Like AJ said, there has to be something in there, some magic language that says the ownership of the copyright and all other IP that's created is assigned over to you, the nonprofit organization. And if you want to use the work made for hire structure, then as AJ said, that can work for certain types of work product, but a very limited array of categories. Then you also have to throw in that assignment language kind of as a default. I call it a belt and suspenders approach. And it's very important that you have in all of your independent contractor agreements, and by the way, you all should have kind of a model independent contractor agreement that you have on your computers to use as a starting point whenever you're hiring any kind of a consultant or vendor or something else. There's a lot of important provisions to put in there, and this is, I think, one of the most important ones. In addition, with your volunteers, your members, your supporters, your committee members, anyone who is contributing any kind of copyrightable or other valuable content to your nonprofit organization, like AJ said, if they're not an employee, then there's not going to be that automatic transfer of ownership to the nonprofit organization for what they create. Yet you want to have ownership for that, or at least you want to have either exclusive or perhaps not exclusive, worldwide, perpetual, irrevocable right to use that work product in any way that you want. How do you do that? You need to get it in writing. It has definitely become a best practice in the nonprofit world to have your volunteers, and I'm talking about the board members, committee members, and also speakers and authors, anyone who's contributing that content to you, to either sign an assignment form. It can be very simple. It can be done online. It doesn't have to be very legalistic or very verbose, but it has to have something that transfers ownership to you of whatever they create, or at a minimum, a broad, irrevocable, perpetual, royalty-free, worldwide license to let you use that content in any way you want, so that when your speakers do speaking presentations like the PowerPoint deck that we did here today, or your authors write articles for your magazines or your journals or your websites or newsletters, you want to make sure that you have the right to do anything you want with that in any way in the future without having to go back and get permission or pay royalties or anything else. You're likely going to want to take a lot of that content and use it on social media. Like AJ was just saying a few minutes ago, you need to secure the rights to do that first, and this is the way to do it.
And when talking about those categories of content creators, note that although we haven't said it expressly here, of course independent contractors and volunteers would include interns, our legions of college kids that come and help us manage social media given their familiarity with it. So don't forget that important bucket of participants that need to be included in this consideration.
I'm going to provide an illustrative case, and even to the point Jeff made that you're not often going to have employment contracts. We don't have employment contracts either necessarily. Most for-profit business, everyone's at will. But your documentation with your employees, with your volunteers or interns, you will commonly have something addressing confidentiality. I would recommend that all of you give consideration to something that addresses proprietary rights ownership. You can have a standalone document that says when you're engaged by the nonprofit to create something on our behalf, you're going to assign it to us. I would recommend that you think about implementing that with anybody that's involved in the creative process. So I'm going to walk you through a case that applies to social media to give you some sense of how this might apply. So in this case, it doesn't answer all the questions, but it gives you a sense of how these issues are playing out. A nonprofit employee set up a LinkedIn page. As a part of that LinkedIn page, they established quite a number of important connections to the nonprofit with a lot of private executives. The employee decides to change, to go to actually a competitive nonprofit organization. They want to take the entire account with them because that account has the contact lists, it has the record of communication, etc. That's a very valuable asset. The former employee sues, saying you can't do this. Now, in this particular situation, I can tell you there was no documentation with this employee addressing the situation. So problems that occurred as a part of this was, one, the employee was allowed to establish the account in the name of the employee. And this happens a lot. It happened with domain names, but it can happen quite a bit with social media accounts. The social media account for your organization is literally in the name of the employee. There's no record reflecting that it belongs to you. Second, the notion of creative works occurring through the social media communication process, through those interactions or as a part of that engagement, again, not addressed anywhere. So there was nothing addressing this scenario. Now granted, these are sort of new scenarios, but when you're establishing your social media presence, the very first thing you should be doing is making sure, go back to this idea of ownership, are all the accounts in the name of the nonprofit? They should not be ever in the name of any individual. Individuals change jobs. It should be in the name of the nonprofit. You can have certainly an individual they contact, but it should be in the name of the nonprofit, and it should be made accessible through credentials or a password that the nonprofit controls. There have been numerous instances where an employee leaves with control of a social media account, and there's no way to get access to it. You have to sort of force your way to get access to it. So when you're establishing your accounts, make sure it's in the name of the nonprofit, and make sure that you have some ability to gain access to it, because the account itself doesn't qualify as any form of IP that we've been going over. Just more or less a service contract, a little bit like a phone number. So whatever rights are established are likely not going to be governed by anything that gives you any entitlement. So these are things you need to be thinking about when you're establishing your presence. So what happened in this case? Well, we did get a decision. Didn't give us necessarily all the answers, but it gave us ideas about where courts could be headed in thinking about these things. Chief among them is that, control of groups, contact lists. I mean, some of this might qualify as confidential information, as trade secrets, because they're non-public. If you might establish a group where you control what constitutes the group, or certainly the contact information, some of this might qualify as, confidential information. The lists certainly, and I keep going over this point, but this seems to be one that is increasingly becoming really, really important. So the list certainly can qualify as trade secret information. And, what about the messages? Well, maybe. In this particular case, the messages were not initiated with any presumption of confidential treatment. There was nothing indicating that the message was supposed to be kept confidential. So the individual messages may be confidential, maybe not. But if you want to have them treated as confidential information, you need to be labeling them as such and identifying for the recipient that they're to be treated as such. And then finally, understand that the court didn't really give a lot of support behind the idea that because the employee was doing this on its own behalf, that they violated any kind of covenant owed to the employer. Simply because in this particular case, there was nothing in writing establishing any covenants owed to the employer. There was nothing violated here because nothing addressed the employee's conduct. And what I'm talking about, again, is the fact that the employee established the account in his or her name and left with all the contact information. You didn't have anything addressing those things, so there was nothing violated in terms of the person leaving. So make sure the account's in your name. Make sure that the account can be controlled by the nonprofit. And then outside of this, give consideration to having documentation in place where the nonprofit's going to own things it wants to own. And now we need to start extending these ideas, not just to things like texts or articles or work product done on behalf of the nonprofit, but social media accounts, content, membership lists. Say that if you establish an account for us, you're going to do it in the name of the nonprofit, and that's going to be nonprofit property. And it might make sense that in terms of your exit procedures, when you have somebody leave you, you might have given thought to saying something to the effect of, give us back all our confidential information. As a part of that process, you might also want to add to this that they should transfer or help you transfer back to the nonprofit any social media accounts in which they were a controlling person or in which they had some conduct that was undertaken on behalf of the entity.
So AJ, I would presume then you would recommend that, A, if you do have employees, many nonprofits and for-profits will have new employees sign like an offer letter. It makes clear it's not an employment contract. It doesn't guarantee employment for any particular period of time. You're an employee at will. However, here are some things that you're subject to, issues relating to confidentiality and conflict of interest, assignment of intellectual property rights, and I would presume you would recommend including things to this end, making very clear that it's the nonprofit that owns these accounts. If the employee is involved in being a contact point for one of those accounts, here's the limitations on that. If they leave, here's what happens, etc. And similarly, I would recommend putting those same provisions, mirror of those same provisions in your employee handbook as well. If that were the case in this case, there probably is a good chance that the judge might have held that it is a breach of the employee's duty of fiduciary duties to the organization, and then there might have been more actionable claims.
And another thing to consider, we're going to talk about it in a later slide. You might be saying, well, we've got a lot of people, and many of them have limited duties. Why do I have to be worried about all this with all of them? We're going to get to a slide that says that not everybody needs to be acting on behalf of the nonprofit when they're establishing or communicating through an online social media accounts. So although it's sometimes the best practice to have this just apply universally, because then you're doing it and you're covering all of the bases, understand that not everybody needs to be engaged. And so what's most important is to make sure that you're doing this with those people that are actually going to be responsible for your online presence.
Thanks, AJ. So picking up from there, now that you guys have a sense of who's creating what for you and what that means, we're going to talk a little bit about the next sort of stage in that thought process of really making social media work for you. And that's talking a little bit about what content you're actually going to be posting there, how you're going to use the social media. As a practical point, I think most people understand at this point that once you put something on social media, you have to be comfortable with a certain amount of give and take. You definitely lose some control once it's posted to social media. All of the social media platforms all of the major social media platforms currently basically provide for unlimited reposting. So once you upload and post something to a social media page, you've got to be comfortable with the fact that from that point forward, others will be able to, repost or repin or retweet or whatever the platform happens to be. They'll be able to sort of replicate your content on their own pages and in their own timelines. I think before, a couple years ago, I think there was a much higher degree of discomfort with this concept. I think we were all sort of thinking a little bit more, old-fashioned marketing based, really focused on the trademark, focused on protecting exactly where it goes and who's using it how. And frankly, I really do think that this summer's past experience with the Ice Bucket Challenge and some of the other successful campaigns that preceded it have really started to change our perspective on that and helped us understand that there is a certain degree of leeway that you might be able to get comfortable with that will allow you to really to explode and sort of maximize your visibility on a social networking platform. Still though, it's important to think of social media content as permanent. There are ways, of course, to take it down once there's been that oops post, once the thing goes up that you don't want there. You can take it down, of course. Facebook provides both a delete and hide option. The delete is always the one you want to go with, because if you hide it, all of your reposts will still live on in infamy and you won't actually have made that big of an impact. The content will still be there. And Twitter allows you to take it down. But the thing is once you put it out there, both from sort of an ethical and also a legal perspective, you really have lost control. People may have taken screenshots. People may have illegally copied it. It might be off the platform at that point in time. So this is just sort of a cautionary overview that while we're all getting a little bit more comfortable with the give and take of social media, and it certainly provides great opportunities, you still have to be very careful and methodical about what's going up there and making sure that it's had the right sort of approval and oversight in terms of its creation.
Krista, I presume you're referring not only referring to these social media platforms generally, but even specifically to those that are controlled by the nonprofit. The Facebook page of the nonprofit, the LinkedIn account, the Twitter account, even those where the nonprofit may have exclusive or somewhat exclusive ability to make the initial post. Still, even after that, you lose the kind of control that, for instance, you might otherwise have on your own website.
Yeah, that's exactly right, Jeff.
In terms of the delete feature too, assume sometimes that the delete only means the delete from your accounts. It doesn't always mean delete everywhere where something might have appeared. Some of the platforms have that capability, but not all of them do, simply because of the manner by which things can get copied or shared. Might more or less take something, reproduce it on someone else's page, and then it's no longer yours. To Krista's point, when they say delete or hide, what they're really talking about largely is your accounts. And the perspective we always take is once you put it out there on social media, it's more or less there forever.
So the one additional point I sort of wanted to make about the creation of content, particularly when you guys are talking about content that you have created yourselves as opposed to some sort of user-generated campaign that you might be running, is the one IP issue that we didn't really talk about at the beginning, and that is, of course, privacy and publicity rights. Remember that any time that you create content, not only do you have to worry about the rights instilled in the person who created it, the copyright rights, or the trademark rights of the brand owner, there are also rights that attach to individuals that appear in the content. This is true whether they are actors, whether they're people you paid, or whether they are your employees sort of that you've captured in some sort of promotional video to try to create a sense of familiarity and comfort in a casual video. Regardless of who it might be, they all have rights that attach to them that prevent the use of their image for any sort of commercial purpose, and that definition can be quite broad. So no matter who it is that's appearing in content that you create, you also need to get a writing from that person that makes it clear that you have the ability to use their name and likeness in this media, and you'll want to use really broad language in all media hereinafter, now known or hereinafter created, in perpetuity, because you don't want any limits on what you can do. This is similarly true if, for example, you guys want to take pictures at an event that you've hosted. Or if you want to, you're holding a fundraising event of some kind and you want to publicize how well it went, there are your members, your guests appearing in those pictures, and you will have wanted to, A, give them notice of the fact that the event was going to be photographed, Usually you can do that in sort of your materials for the event. Also, you can post a sign in the lobby. I'm sure you guys have all seen those sorts of signs. And if there are faces, if there are individuals that are featured really closely, like people whose images are just right in the middle of the photograph, the photograph appears to be of them, I would definitely caution to get a specific sign writing from that person. Although privacy and publicity rights aren't definite. I mean, there are cases where somebody's image or somebody's face is sort of distant enough in the background that they don't actually legally require any sort of release. From a practical perspective, because these people are your supporters and these people are your members or your friends and colleagues, you do really want to go out of your way to make sure that they're aware of how their image is going to be used. Because the last thing in the world you want, aside from a legal issue, is sort of a PR issue of having exposed somebody's support for your organization that they didn't necessarily feel like they want publicly exposed.
And go ahead. Sorry. This is an issue we deal with quite often. It's also an area where we find a lot of confusion, for instance, between the right of privacy and the right of publicity. And by the way, the right of privacy applies to regular folks like most of us. Maybe some of you are the exceptions, because the right of publicity applies to famous people. And there are definite differences and nuances in the common law rights in those two areas. But we often find confusion between that and copyright rights. So for instance, with a photograph or a video, the person who is taking the photograph or taking the video is actually the owner of the copyright in that work. Or remember, if that person works for another entity and that is acting within the scope of employment for that entity, then that entity is the one who's going to automatically own it. Or if they had signed something saying they assigned the rights to the company or the nonprofit that hired them to create that video or that photograph, then the nonprofit is going to own those rights. But that is very separate and distinct from the right of privacy and publicity that Krista was just talking about. They're two separate things. They coexist at the same time, and you need to deal with each of them separately. We do have a question from one of the webcast participants asking about a fairly new app called Periscope, and there's another one called Mercat, which enables people to fairly easily broadcast video via Twitter from events. And this person who's at a nonprofit has dealt with challenges of people using Periscope to take videos at their events, including of speakers and speakers' presentations and attendees, and then broadcasting them and dealing with pushback and flack from the speakers, for instance, who didn't necessarily give permission for their video. They might be comfortable speaking in front of the audience, but it might be a no media situation, or otherwise believing they're talking to a small select group and not to the general public, yet that's being broadcast out to the world. So the question is, what practical guidance recommendations do we have for nonprofits in this situation to try to, if you want to, try to curb and limit that sort of behavior, to put limitations on it? And in some cases you may not. I mean, sometimes nonprofits want to have an event and they're thrilled with getting publicity and broadcasting it to the world. Sometimes, by the way, the same thing goes with content. Sometimes you may put out content and you want it to be as widely distributed and published without, you don't need, you may want attribution, but you don't really care about otherwise getting permission. Other times it's a much different situation. You got to be cognizant of those. But in these situations, presuming you do want to put some limits on this, any practical tips or suggestions?
First, I'm going to say that you just described a whole bunch of apps I tell my kids they can't use. I think if you're under 21, if you're using a social media app that's been around for longer than 6 months, it's no longer cool. So they constantly are looking for new apps to use. What they all generally do is allow you to take video, take pictures, or send texts in some kind of way. They have different mechanisms connecting people, but the bottom line is it pretty easily allows people to share content. This isn't a new question, but it's just one that you need to deal with now because the ability to record video, take pictures, etc., is easier than it's ever been. I think when you're hosting an event, you need to set the ground rules on what's permissible. This is no different than the way people have been managing concerts for a long, long time. If you want people to take pictures, record, tell them they can. If you don't want them to do that, tell them they can't. Whether or not you're going to be actively policing is another matter. But at the end of the day, this is a situation where you need to establish the rules, because we're tying this back to the right of publicity question we were going over. Can you use somebody's picture or likeness? The answer is you need to consent to that person. And if they haven't given it to you or given it to everybody who's taking a picture, you may not necessarily have it.
I think the other practical point to consider there as well is the contract you have with your speakers, or even if it's not, even if it's an employee or your CEO, the notice you give your speakers that while you are taking reasonable steps to make sure that there's no photography or videography if you don't want it, that you're not accepting liability for any content that might slip through, any content that appears online. So you should have a disclaimer that basically says all you're required to do is take reasonable steps to prevent it, but that you won't ultimately be liable in the event it ends up online. Let's see. Okay, so moving on. Oh, sorry.
Yeah, go ahead.
We have a question.
Yeah, I was wondering how that extends to if you're not sharing media, but you are tweeting direct quotes from the presentation or something like that. That's another way that the material is getting out of the room in a shared way, and I'm wondering how that is covered.
A quote would be largely covered by copyright law. There's no sharing of someone's likeness generally. I mean, if you have a picture of them in the quote, and then you're combining two things. But, you know, does the quote copy enough for you to be infringing? I mean, well, the answer depends. I mean, there have been cases involving poems where you copy the line of the poem, and that is sufficient for infringement. There's been other cases where you copy a single line out of 4,000 pages, and that won't be. You know, with Twitter, it's a difficult question. I will say that most people regard the content of Twitter, in which I think it's up to, I don't know how many lines it is now, but as being of the kind of content that can constitute creative expression subject to copyright protection. So what you post on Twitter is protectable, and certainly what you copy from someone else and post on Twitter could theoretically be protectable too. So at the end of the day, usually better to ask permission.
And yeah, AJ, do you want to speak to that for a minute? Because we've been focusing a lot on written content. But nonprofits do, as we talked about earlier, have lots of events where there are lots of speakers and speaking presentations. You want to talk about for a minute kind of the protection for the spoken word under copyright law, and what sort of tweeting out of a particular potential copyright protected elements of that speech could lead to copyright infringement claims?
Copyright gives you rights to do certain things. The most common right is copy, but performance is another. And so when you're dealing with copyrightable works and you're asking or seeking permission from someone to do something, so in the case of a presentation like this, you are the nonprofit hosting the event, you want the ability to rebroadcast, redisplay, retransmit the content of this presentation in different forms. That means taking quotes, taking video snippets, putting a whole video up. You're going to want to cover all the bases, unfortunately. These copyright rights can be divisible. So if you ask for one thing, you may not have rights to another. There have been numerous cases, particularly one to the Supreme Court, about distribution rights where articles in print were deemed different than articles in electronic medium. Those are separate rights. The rights of a licensor are always very specific. And generally speaking, operation rule that we always follow is if you didn't get express permission, then you may not have the permission. So when you're trying to address how to distribute content of your presenters, I mean, just say, hey, we want to distribute this through all forums, through all media, through any mechanism possible, in whole or in part, and we may include your video.
And as we mentioned, one second for your question, as we mentioned earlier, ideally you want to try to get an assignment from folks who are contributing content for you. And usually when you're paying for something, it's easier to, just from a business perspective, to convince someone to sign over ownership of that content to you. Oftentimes with volunteers, and we see it all the time in the nonprofit community, it's a lot harder. In fact, AJ, Krista, myself, we do a lot of speaking for other nonprofit organizations. As I said before, it's a best practice to get speakers to sign a form. Whenever I get a form that asks me to sign over the copyright, assign the copyright of an article or speaking presentation to the nonprofit, I type up a revised version with a license. I say it's a non-exclusive license. You can use it in any way you want, in any medium, without permission, without paying royalties. But you can't have ownership of it, and you can't have an exclusive license. And so you need to be aware of these nuances so that whatever you want to secure the rights that you need, get the maximum rights that you can, but when you get pushback, you need to know how to negotiate the right resolution too. You have a question?
I wanted to ask a question that relates to some of the things we were talking about. Yesterday I received an email from an organization that we highly respect, and they wanted to tweet an article that we had written that was in their venue that they're interested in. We'd be happy to have them do that in a sense, except that what they had done was they wanted to tweet basically our whole newsletter. And so in other words, they would start it at that article, but then the way we have been doing it lately, there's some reading software that, turns the pages for you and all that sort of thing. So you get the whole thing. Well, we did have a workaround that was very acceptable to them, where we gave them a PDF of the article, and we said you're free to post this and tweet this to the, to the extent you care to. But my question is, what could we have done, and what should we have done if they hadn't asked us? Because they probably could have done that.
Yeah, well, I mean, first of all, kudos for developing the workaround so everybody could walk away happily. I mean, I think that's the end goal all the time. But, I mean, essentially, if they had done that without your permission, I think there are a couple things you could have done. Depending on, did you guys tweet the article originally, or was it just sort of in a newsletter you did? Yeah, then I think, I mean, you would have been able to say to them that you would have been able to claim that they were infringing your copyright. Unfortunately, had you posted to Twitter, which I understand isn't the question, but when you guys do post something to Twitter, because of the Twitter terms of use, all other users are allowed to retweet it. So if that had been your avenue of dissemination initially, you wouldn't have had that recourse. But if they are distributing something that you haven't given them the authority to distribute, you can claim that they're infringing your copyright and ask them to cease and desist.
Yeah, and an important corollary or a background note that you should be aware of, and we don't have time to get into this kind of detail in today's program, but it speaks to the importance of copyright registration. Because whenever you're putting out copyrightable works, magazines, journals, newsletters, your website, other things that are subject to copyright protection, you always want to get in the habit of registering them within 3 months of the initial publication with the U.S. Copyright Office. Because then in the event that you have a situation where you have an infringement, sometimes they're innocent and they're easy to resolve. Other times they're willful. Sometimes they're done by competitors. Often they're done by for-profits trying to make money in the same field and space that you're operating in. You want to have the full leverage or full arsenal of kind of legal weapons at your disposal, and registering your copyrights gives you a much stronger, greater arsenal. It gives your cease and desist letter much greater impact and weight than if you hadn't registered the work either within the first 3 months of initial publication or before the infringement occurs. It has to do with statutory damages versus actual damages, but it's very important. It's something easy to do. You can get all the forms off the Copyright Office's website. You don't need a lawyer to do it, but I highly recommend having at least one person dedicated on staff to registering your copyrightable works on a regular basis. Separate and apart from that, we have the issue of trademark registrations, which is a more complex process, also though very, very important.
And so just to round out the response to that question, I mean, we do have a slide in a minute that talks about like avenues forward, for example, for getting something off Twitter. So aside from sort of sending the cease and desist to the organization, which would have been the deemed infringer in this case, going to Twitter and asking them to take it down. We'll get to that in a moment, so I didn't go into any detail on that now.
Yeah, a question here.
Yeah, we have several events that we have high-level employees speak, and they know they'll be videoed, and then we're going to put those videos on the website, and then we're going to tweet them out. We're going to put them on our YouTube channel. Should we be getting releases from all of those high-level employees? We don't have anything in our current manual.
I would probably bake it into some other general employee guidelines. I'm not sure I would necessarily seek out a specific release because, you know how executives are, always thinking they're special. So they're probably going to ask for things that you don't want to necessarily give up. But I think it's a good idea in this day and age, particularly as video becomes a more prominent means of conveying information, to just say, hey, as a part of your duties, you might be disseminating information. We might take video of it, and we might distribute it, and have that as part of the process.
Yeah, build it into that offer letter, build it into your employee handbook, that sort of thing, so that every time your employees show up in a video or photographs you're taking at your annual conference or something like that, you don't have to worry about getting permission. Okay, let's move on. Okay, one more question back here.
Sorry, you already answered this, but what about a watermark? Can that be used in a place of like copyright? Does it have any legal standing? Putting a watermark on an image or something?
In what sense? A watermark to say that you own something, or a watermark?
Yeah.
When do you back up and just talk about copyright notices for a second?
All right, so any kind of notice on a copyrighted work isn't required anymore. And the most common notice, or the notice that everyone would otherwise be thinking of, is the little C in the circle. But it's a good idea because with the notice, you're entitled to greater damages if you're ever in an enforcement setting, okay? So placing a little C on something to designate it as your copyrighted work is a good idea. Additional watermarks like, property of nonprofit, or very commonly you'll see professional photographers that put their name on it. That's fine too. I mean, it's just another way of telling people it belongs to you. Does it disrupt or interfere with the presentation of the information? Maybe. So I'm not advocating that you have to put watermarks and everything, but providing that notice is just another way of telling people it belongs to you. I think there are less intrusive ways of doing it, unless the whole point is to make the photograph available. So the reason why professional photographers put it in the background is because they don't want people reproducing the photo until they come to the photographer and pay for it. So they, in a sense, damage the photo by putting in the watermark in that manner. In your case, I mean, I'm not sure if that's necessarily the goal. It could be, but if the goal is simply to identify if the property is owned by you, I think there, a footnote or something smaller or something connected to the photograph might be another way of doing it.
And there are programs out there, and I am not the one to ask about them, but I know because I get a couple newsletters that make very clear you're not allowed to be, these are paid subscription newsletters that some we get in the nonprofit tax area, that make very clear you can't forward them to anyone. Not to forward them to anyone at all, but the way the protection is built in is that it won't let you forward it to anyone outside of your organization, outside of anyone with the same domain name. And we've had people try by accident, and it literally doesn't work. So the extent that you have newsletters that you're sending out to members only, or others where you want to control access to your content that you're sending out electronically, you should look into technological avenues to protect it.
In that sense, the watermark is really digital rights management. So there are places to go for free photographs, and they're now watermarking them. But what the watermark does is prevents redistribution, and to a certain extent, it drives you back to the place to pay for the photograph. But that's just digital rights management, meaning it's controlling the use of the photograph in a certain way.
It definitely doesn't override what the terms of use say on Facebook or whatever. So if there's a photo that somebody posts to Facebook that it has a watermark on it, the other users of Facebook are still going to be able to repost that.
Right. It doesn't mean that the original poster couldn't be subject to a copyright infringement claim if they posted it illegally, but anyone else who's using it after it's on Facebook, it cannot be held liable for contributory copyright infringement. Okay, one more question, then we're going to move on here.
AJ's comments on the little c, that you don't need it anymore, is that also true for the little r?
Different things. Now, when I say don't need it, that doesn't mean I don't recommend it, but it's not necessary to claim copyright protection. The R is a trademark symbol, and it does have a specific meaning. It means it is registered at the U.S. Patent and Trademark Office and on the principal registry. You cannot use that R unless you have actually obtained such a registration. So that's a little bit different, but ultimately it's serving the same purpose. It's putting people on notice. And that notice helps you in an enforcement setting, because if you copy something with the notice attached, you are engaged in what might be more considered intentional copying or intentional infringement.
And we do highly recommend always using copyright notices, sample of which you can find on the cover of our PowerPoint today, as well as trademark notices. If the R with the circle around it, if it's federally registered on the principal register, and the little TM or SM in superscript for non-federally registered marks. All right, Krista?
Okay, so just to keep moving along, we did want to raise one case study today that has to do with a different social media platform, as AJ mentioned at the start, and this is Pinterest. We're not targeting Pinterest necessarily because all of the social media platforms offer similar functionality, but this is just a particularly good working study for how one of the, I guess, warnings on how to be using social media. So I think everybody sort of understands at this point in time that having social media pages that aren't active isn't of a lot of value. I mean, in order to really draw people to your social media presence and engage online, you've got to be actively posting things there. And where you get that content is an issue for everybody. What to post, where to get it from, who decides what goes up, right? Pinterest is a site that operates as an online pin board. So it's basically taking images that are found all over the web and repinning them to Pinterest. From a basic standpoint, there are copyright issues there, right? Because if there's an image on another site and you right-click it, copy and save it to Pinterest, you've now loaded it onto Pinterest's servers. Some of the social media sites are a little bit different with respect to who actually makes a copy on their server, but just thinking this through to its logical conclusion, you've now taken something you don't own and you've posted it elsewhere for public display or distribution. Arguably, that's an infringement issue, right? So there are some issues with how do you use Pinterest successfully? How do you use Pinterest and other sort of content sharing mechanisms on social media without really confronting risk? The first thing to think about is that the terms of use, as we've already discussed, the terms of use of these social media sites basically say once you guys upload it, other people on the social media site can repurpose it, right? They can send it around, they can share it with their friends, and you don't have control. So in order to get to that point, you as the initial poster have to make broad representations that you own the rights, that you have all rights to upload and let the content be used in accordance with those terms of use. That's where the risk comes in. The other thing to consider is that the sites from which you're getting this content, they likely have terms of use that say don't take our content, right? Don't take our content, don't post it elsewhere, this belongs to us. So when you're engaging in that sort of pinning activity, there are a lot of copyright issues that can create risk for you and for your nonprofit. The thing to consider when wanting to sort of build out your social media page to make it look nice, to make it look vibrant and active, is A, the safest course of action will always be to just pin your own content. Pin stuff that you've made, that, promotional materials, marketing materials, photos from events, all of the things that we've been talking about today, that stuff you own, and that of course is okay to pin. The next best option is to engage in sort of reposting, because as the terms of use are laid out, as not the original poster, you actually have a license to repost the content that another original poster posted, right? So it sort of removes you. You're one step removed. And then of course the third is that there are sort of the little like buttons and the pin buttons that you see on third-party content sites that suggest that the owners of those sites might be okay with this type of sharing, although it's no guarantee, right? I mean, it's no guarantee. That's not going to be I don't know, that might be a successful defense in court, but don't quote me on that. I wouldn't want to be in the position of claiming that as my defense. So the only 100% risk-free course of action is to only post the stuff that you create. But there are sort of levels of increasing risk that you can keep in mind as you proceed.
And as we talked about at the outset, nonprofits, perhaps even more so than most for-profit companies, don't always have employees creating all of the content. You rely heavily on paid contractors, on consultants, on volunteers, members, etc. And as a result, it's very important not only to get the copyright assignments or licenses that we talked about in writing, even though legally there can be an implied or a verbal license. There can't be an exclusive license unless it's in writing. There can't be an assignment unless it's in writing. We always recommend it be in writing though, regardless. You also want to include provisions in there, perhaps the second most important other than the license or the assignment, being that the person who's giving you those rights represents to you that they have the right to give you those rights, that they're not infringing anyone else's rights. We've had a number of cases in the nonprofit community where a nonprofit published some article that was given by a volunteer, member, author, etc. Turned out that article infringed someone else's copyright. If there is a representation from the contributor, from the volunteer, that he or she had all the rights. If there's photographs, they have the rights to use those photographs. The content is their original work, or they got permission from others to do that. If it turns out that there is later copyright infringement and there's a claim made against the nonprofit organization, you're going to have a pretty strong claim there to avoid being held liable for contributory copyright infringement if you get those representations from the donor.
So sort of, yeah, thanks, AJ. I have like a mental block about forwarding the PowerPoint. So once you've got the content created, the next thought in your sort of social media program needs to be, how am I going to enforce this content? As AJ and Jeff have already talked about, there's a focus on registration here. You need to have the works registered because in the event that you have to take legal action, the benefits of registration are countless. And in fact, in the copyright context, you can't actually file suit without a registration. So always good to register up front rather than be sort of going back after the fact to try to get the registration you need.
Do you want to talk for a second also about the value of trademark registration in the domain name context, you or AJ?
Yeah, sure. So the reason why the registration is so important, why we keep coming back to it, is because some of the procedures will allow you to complain, but many of them will not allow you to actually enforce your rights and lead to action. Something's being taken down or stopped unless you have a registration. So with copyrightable works, you really need that registration for enforcement. Same holds true with trademark, and with respect to domain names, it's not really social media, but for example, an account name. If your name is being used in someone else's account, you really need that trademark registration to stop that person or entity from using your name. So the registration is important for enforcement.
We'll talk about the next bullet. Sort of is a general bullet on monitoring use by others, and we're going to talk about that a little bit more in a second. I'll get into the DMCA. But the point I wanted to make specifically on this slide is to be aware of, we were talking earlier about how the balance between controlling your content and achieving maximum exposure on social media has sort of changed the equation for what people are using online. Another component of that is how you enforce your rights and how that's changing online. So I just wanted to quickly touch on two case studies that are now a couple years old. World Nutella Day and this Jack Daniels issue. Both were trademark infringement issues. They were handled incredibly differently, and both of them went viral to much different ends for the companies. The first one, World Nutella Day, I don't know how many Nutella fans are out there, but there was a lifelong fan of Nutella who created World Nutella Day. It had been around for like 10 years. She had a Facebook page. There were bakeries and shops buying in this. It had sort of grown virally into a very impressive campaign. Inexplicably, in 2012, the owners of the Nutella brand sent her a cease and desist. She was literally a fan. She was a fan who was doing this because she loved Nutella. She wasn't a competitor. She wasn't really trying to she wasn't trying to get ahead based on the name. So they sent her a cease and desist, and it was a very standard cease and desist of the same form that's been around for years. It basically said, stop now or we'll sue you, basically. She reacted quickly, took the site down, gave a bunch of public comments that basically said, look, I just love Nutella. I would transfer this site to them. I would transfer all the rights to them if they wanted it. I'm just in this because I love the product. Fans, of course, went crazy. The negative feedback was immediate, and it was harsh. The Facebook page is just rife with terrible comments about Nutella because this letter went out. Ultimately, they reversed course. They told her, nope, sorry, never mind, you're fine, keep doing what you're doing. And World Nutella Day came back. But I think the negative PR that the company received based on just sending what was probably, honestly, a form cease and desist was, it caused tremendous harm from a PR perspective. Where on the other side, just a couple months later, a small author published a book using the Jack Daniels logo as sort of part of the cover of the book. He put it into production. It went out to print. The Jack Daniels folks saw it, wrote a cease and desist letter that was incredibly nice. It was basically saying, we recognize you're a fan. We recognize, you're from, I think he was from Kentucky. It was like, we have the same origins. We really appreciate your support and promotion on this point, but because we're a trademark owner, we have an obligation to limit the uses of our trademark and sort of enforce and protect our rights. So all we're asking is that in your next print, you don't use this same cover anymore. And if you want to take action before then, we'd be happy to split the cost of doing that with you, or maybe even they said share or take on the full cost. I don't remember specifically. That cease and desist also went viral to the exact opposite reaction, right? It was on blogs. It was picked up by the mainstream press. It was like, this is what lawyering should and could be in a cooperative, happy environment, So just a warning that with the changing landscape, we've also sort of got to consider that cease and desists and other enforcement rights aren't happening in a vacuum anymore. It's not just like click and go. It's like you really need to think about who's going to see that letter because you don't know where it's going to end up, and you want to be aware in advance of how that's going to reflect on your nonprofit. AJ already talked about the use of symbols, so I won't spend much time on that. And then, of course, the most important point, which we're about to get into, is network operator takedown policies and procedures. So this is where you get when somebody is using your content in a way that you don't like, in a way that you consider not authorized or infringing. I'll start by giving a quick background on the DMCA because remarkably, we haven't really talked about that, which is crazy because I feel like that's always one of the first things that comes up in these conversations. But the Digital Millennium Copyright Act is the statute that basically sets up the takedown and the notice and takedown procedure that I think most folks are familiar with here. It's a way of protecting your copyright online, and importantly, in this context, it doesn't give a claim. You don't sue somebody under the DMCA in this context. It acts as a defense. It acts as a defense for the intermediary platform and other actors, but I'm sort of limiting this to the social media context. So this is the way that Facebook and Twitter and LinkedIn can all be sure to be protected from copyright infringement claims if copyrighted content ends up being shared on their network to the chagrin of the copyright owner. The way it works is that if the copyright owner submits a copyright infringement claim to the platform and basically says, hey, Joe Smith is posting my content without permission, it's a copyright infringement, and they include certain required information in that notice, the platform has to take action on that. They have to notify the poster of the content and say that the content has been the subject of a claim, and they're going to take it down if they don't receive a counter notice. The original poster has the opportunity to submit a counter notice, and if they do, the content goes back up, and the only way to get it back down is to go to court and fight about it. Practically speaking, very few counter notices are ever filed. Because frankly, if somebody doesn't own the copyright, they're not going to make a statement saying that they do. I mean, it's possible that a lot of people choose to look the wrong way and post content they know is copyright infringed because they don't think they're going to get caught or they don't think it's a big deal. That certainly happens, but it's very rare that somebody actually posts content you own and they think they own it. So it very rarely gets to that point. But when it does, an important thing to consider is you can't take that next step of going to court without the copyright registration. So if you're a legal copyright owner at that point without a registration, you don't have any further recourse against the platform, that is. And the important point there is to distinguish between the copyright infringer, the dude who posted it, and the platform, right? These are two different actors. So nothing about the DMCA affects your right to send a cease and desist and pursue the poster for copyright infringement. That remains available to you. But what we're talking about is what obligations the platform has to take action based on copyrighted content that appears there. So all of the platforms pretty much universally on the copyright side follow the DMCA steps to a T. The reason for this is this is their defense in court. If they follow all of these steps, they can't be held liable. So there's not going to be much wiggle room. There's not much difference in how these policies are applied. All of the sites offer you sort of a click-through way to sort of submit the notice, so you don't have to go to the extent of writing a letter. You can just submit it through their online forms. There's a list of required content that you have to put in your copyright notice. We've sort of summarized it here. In each case, the platform will then notify the infringer, and if there's no counter notice, the content will be removed. The other important component to the DMCA is that the platforms have to have a repeat infringer policy. These are actually pretty loose. The statute doesn't say how many infringements is repeat infringement, but it just says they have to have a repeat infringer policy that will ultimately result in termination. So if there's a user who's only posting copyrighted content and they get notice after notice, there has to be a termination of their ability to use the platform eventually. On trademark infringement—
Before you go on, Krista, you might think, this is interesting, but how is it relevant to us as a nonprofit? It's important protection for the platform, for the social media platform, but not for us. But nonprofits uniquely are fairly unique in that nonprofits often run their own platforms where members or volunteers, donors, supporters can share information, engage in dialogue, share content, perhaps copyrightable content, where the nonprofit itself is serving that third-party role, basically where content is being posted by non-employees of the organization. In the DMCA, we found and advised many nonprofits over the years to utilize these mechanisms, these procedures, for their own protection in this context. It's a very important thing to remember to do.
This is also the procedure you want to follow first. If someone's posted something you don't want them to post, you should do this first. We mentioned how there can be some backlash and publicity. This is generally a private process outside of the counter notification. It doesn't necessarily even require a lawyer to do it, although we can sometimes help craft it in a way that makes sure that it gets received and responded to. And the other thing, too, is that it can happen very quickly. the copyright side in particular offers immunity to the operator, so they have every incentive of following this. Whereas a lot of other procedures, they may get around to it eventually, or you may not have anything happen quick enough for you. So if you have content needs to come down, this is the first thing you should do.
Yeah, and I think it is relevant also in the social media context for you guys. I mean, just an example that I think might be relevant is if you guys hold an event and it's your sort of annual ball or annual gala, it's a big deal, and somebody else is using a photo of that gala as their Facebook page photo, that's a copyright infringement, and you're going to want to get that down. I mean, they're basically creating an insinuation that that event was theirs, and these are the processes that encourage the platforms to work with you on that, because if the DMCA didn't exist, it's questionable, what their motivation would be for working with you to get that content down. But as I started to say earlier on the trademark infringement side, because there's no DMCA corollary in the trademark world, the process is a little bit less specific. I mean, the fundamentals are the same. You submit a complaint via an online link or button. Same with DMCA. You've got to include certain information that all of the platforms will list for you, sort of in bullet point fashion, all of the things that you need to include. And in some cases, they'll take the content down. But if you go to the next slide, here's where it gets a little bit interesting. Because there isn't a step-by-step process on trademark like there is for copyright in the DMCA, the procedures for getting trademark infringement content down are a little bit looser. Facebook, for example, provides your name and contact information to the original poster. So they'll tell you based on they'll tell that person based on your registration information who you are. And they encourage both parties to reach out to one another and try to reach resolution. If there's no resolution, if the parties work together or choose not to work together and can't resolve it, Facebook actually makes a determination about whether there's been an infringement, which is an interesting thing because somebody in their compliance department is presumably looking at it and making a judgment call based on the law. If you have an infringement issue in an ad, it's a little bit easier to take care of because there's a constrained reporting structure within the ad image that you can click on. But I think ads are sort of its own, advertising on social media is sort of its own presentation that we're not really going into today, but I thought that was worthy of mention. Same with Twitter. If there's a trademark infringement case on Twitter, Twitter is at some level making a determination of whether there is in fact an infringement. I think their terms say something like clear intent to infringe, and if they don't find a clear intent to infringe, they do the same thing Facebook does, which they say, hey guys, basically work together and figure this out. Twitter has said that they are in the process of figuring out a way to sort of automatically release names into the power of the trademark holder. So if somebody has a Twitter handle that's infringing on your trademark, they say that they're in the process of working out a way to get that to sort of automatically become yours once you complain. But as of right now, what happens is you submit the trademark infringement claim through their submission form, and they just sort of suspend the account so that the current owner of the account can't take any more action.
We're going to jump through these last couple slides just to make sure we have some room for questions. So on this
wait, AJ, one point before you get into the question from one of the participants that I think is an important one. We get a lot of confusion on this. The copyright issue, and someone said, well, if we attribute the author or the owner or the creator of the copyrightable work, doesn't that save us from a copyright infringement claim?
The short answer is no. You need permission. Attribution sometimes can look like permission, but it actually isn't express permission. And so when you're seeking consent or permission from the author, you really need to get that. Now, in terms of whether or not you have to use or have to follow an attribution requirement, you don't have to. In some practices, it's considered a good idea or even ethical or even something that's generally accepted practice. You tend to see that in educational environments, but at the end of the day, attribution isn't a requirement, much like copyright notice isn't a requirement. But attribution of itself isn't any form of permission. You need express permission.
But it can, that's exactly true. But that's the answer I typically give to that as well. But when I also add is, when you give attribution, it does tend to make the copyright owner a little less pissed off. In fact, we had an instance recently where one of our federal grant and contract newsletters was literally copied and pasted into some commercial for-profit newsletter, and we would have been absolutely fine with that and always are if they would have said, written by so-and-so and so-and-so at Venable. It didn't say any of that. It just had the content. I think handled it in the right way. We did not send an nasty cease and desist letter. He agreed to give us attribution and do that going forward.
I think it'd be very difficult to claim intentional infringement when attribution is there, which means that the kind of damages you hear thrown about sometimes for copyright, in particular statutory, aren't really going to be available. So to your point, there is that side benefit, but it isn't going to serve as any kind of shield.
And when you, your nonprofit, are wanting others to push your content out there, that furthers your nonprofit taxes and purposes. That's all well and good. But you also want to get you want to get the attribution. You want to get the credit for that. So as any kind of a blanket license or any kind of express license you're giving to people, you may want to make clear that they can use it, but they have to attribute it to your nonprofit.
So on this side, this is basically saying not everyone needs to communicate on behalf of your organization. Give consideration to who's authorized. Use your normal communication procedures. You don't have to reinvent the wheel for social media. You have possibly given thought to who can speak on behalf in other forums, TV interviews, etc. Apply that thinking here. If people are going to be communicating online in their own personal capacity, then limit their ability to use certain forms of IP. It may be appropriate, and this is pretty much why LinkedIn was created, for them to identify their job title and their employer. That's different from allowing them to use a stylized logo or other kinds of property. Just because they work for somebody doesn't mean they have permission to use. And in addition, make sure that they understand that they can't use a nonprofit's name as their account name. So that is really just another type of trademark infringement. So, these are sort of guidelines really for the employee to understand that when you're acting in an individual capacity, these are things you can't do. Well, we're going to just do the last two slides, and then we'll open the floor to questions.
So real quick, just building on that notion of pages and who gets to create them and why. I mean, here's sort of the rundown of what you have to, what your qualifications need to be in order to register a page on the three main social media networks that we're talking about today. I'll make just a couple of points here. I mean, the first is Facebook pages. Something you guys will want to be thinking about is the differences between pages and groups. Just from a practical perspective, a page is open to everybody. It's their preferred course of communication for businesses. A group is can be a private group. You can restrict people who can access it and view it. So that's really not as applicable for business or nonprofit use. Twitter handles, they don't really have a page equivalent on Twitter, so it's all about what the handle is, what your Twitter name is. And LinkedIn company pages have some standard company requirements. You have to have an email account that's registered to the domain of the company. It can't be like a Gmail account or anything like that. And you need to be an employee with your own page created and have had that page created for 7 days at least. And then just finally, to sort of round out the topic of social media and things you need to be aware of, the ability to control sort of your employees' use of social media. This, again, is a whole issue unto itself, and nobody up here professes to be a labor and employment lawyer, but we did sort of just want to highlight a couple things for you to be thinking about. It does matter what employees post online. If there's ever an event where you're being investigated or God forbid, sued, content of your employees' social media accounts can be subpoenaed for use. So it does sort of matter how your employees are using social media and how that interacts with your organization. Also, to the extent employees are complaining about their job on social media, nobody wants that to be the case, right? That sort of seems like one of the worst case scenarios for employee use of social media. Be aware that there are National Labor Relations Act requirements or restrictions on your ability to terminate somebody from making certain public statements if they are protected under the National Labor Relations Act, which extends beyond just union employees, by the way, so that may apply. So before you take action based on a comment that somebody makes, one of your employees makes about you on social media, be sure to consider those issues and perhaps consult a lawyer. Yeah,
and just as an aside, and we've written some alerts on this, it's an important issue that a lot of nonprofits don't even think about or are not aware of because most nonprofits don't have unionized workforces. But the basic idea is that workforces do have the right to unionize. Obviously, these rights vary state by state. And the National Labor Relations Board has said that social media is one mechanism for doing so. And so employers, including nonprofits, have to be careful about restricting employees' rights to make disparaging remarks about the nonprofit using social media. Of course, there's a fine line between that and defamation.
And then finally, one of the current trends in sort of the legal realm with respect to social media is that a number of states have passed laws that basically make it illegal for employers to request that employees give them access to their personal social media pages. So just put that in your pocket. It's not something you want to do. You don't want to say that they have to, you don't want to say to your employee, like, as your boss, you need to accept me as your friend on Facebook. That would not be a good course of action.
And distinguish that between the earlier points about the account established for the nonprofit ought to be the nonprofit's account. But you don't want to have to force or ever ask an employee, generally speaking, to have access to their personal account. Although there aren't full 50-state laws prohibiting this, the general trend is just don't ask for the access.
And while I know you have a question here, this gentleman here, question for you guys, and it came from a question from one of the webcast participants. We talked a lot about social media platforms posting material that may infringe someone's copyright or infringe someone's trademarks. We didn't talk much about content that might be defamatory or might, say, invade someone's privacy. There are other legal rights that can be touched by content that's posted on social media. Do you want to talk for a second, AJ, about kind of the right, but let's say a nonprofit finds that someone out there is defaming the nonprofit organization, saying negative, untrue things that hurt its reputation, or perhaps posting confidential trade secrets like a donor list or a confidential member list. What sort of rights does a nonprofit have via these social media platforms to do anything about it?
Sure. So I can talk about it two ways. Defamation is its own sort of cause of action. It's really about harming reputation. All of the major platforms, including the three we're talking about today, will allow you to submit, in a sense, a takedown request over content that's defamatory. So they're not copying something impermissibly. They're just sort of saying something bad about you. I will tell you, though, that they all do a bad job of it. You've clearly read in the papers how much trouble Twitter is having over really, really harsh statements made through responsive comments. And so these takedown procedures are not quite as immediate as the copyright procedure by way of comparison. So you can use those mechanisms if you need to have something taken down, but don't always assume that they're going to be terribly effective. So sometimes what we'll do, even if they don't fit neatly in a basket, we'll submit the takedown request through all the avenues and just hope that one of them hits, because at the end of the day, your operators don't want to be in the middle of any kind of fight. Another thing to think about is the slide regarding apparent authority, okay? Negative statements can be attributed to your organization. So if your employee says something negative that constitutes defamation, depending on the capacity in which they said that, it can sometimes be attributed back to you. And so you need to be careful of what they're saying, because it's not just about stopping someone else. It's making sure that your employees don't get you in the hot water about their own conduct.
And we've had similar situations take place, not just with employees, but with volunteer officers and directors. I'm sure many of you have been involved in situations where not all of your officers and directors are on the same page on a particular issue. We're basically refereeing several fights within the boards of various nonprofit organizations where there's a lot of heated, ugly battles going on, some of it playing out in social media. These are tricky issues that you can deal with through the social media platforms, but you also need to deal with internally, and sometimes reminding your officers and directors about their fiduciary duties.
And remember, these forums are for communication. The reason why I said they're doing a poor job of it is because they're trying to figure out where the line is. There's free speech concerns here too. And the whole idea of these platforms is to communicate. So just don't assume that you can just sort of stop someone from saying something negative. So although there are mechanisms for it, it is a little bit of a tricky item sometimes.
Yeah. Question right here.
I was just going to say that Virginia just passed a law that takes effect July 1st about the not asking for employee passwords. But on the prior slide, you had a bullet that said prohibit unauthorized individuals from using entities' intellectual property, logos, etc. Our friends at the National Labor Relations Board have said that, oh no, you can't not let them use your logo that's trademarked, etc., when they are acting in protected concerted activities, because your logo is recognizable, your name is recognizable. And just in the old days when they would picket in front of your store and they would put your logo on the picket so everybody would know it, they're allowed to use that. Now, whether you want to put that in your handbook or not, I wouldn't go advertising that, but it's annoying.
Specific nuance, and what they're speaking to is the idea that the logo itself is not being used as a trademark at that point in time. And so they're saying that that's free speech, and even though it's negative speech about your organization, you're authorized to engage in it. You've heard of notions or things called fair use. That's what they're talking about a little bit. I wouldn't take that statement too far, okay? It is something where if they're using your IP in a way that is a little bit more than just simply criticism, then you're going to have grounds. But you know, in terms of a handbook, I think it's appropriate to still tell people you don't get to speak on our behalf or pretend you're speaking on our behalf by using our IP. That isn't the same as saying you can never talk about us.
Yeah, and there's also another important legal reason for doing that. There's a 1980s U.S. Supreme Court decision that held that some volunteer leaders who were acting with the apparent authority of a trade association, even though they didn't actually have the authority, they were engaging in some anti-competitive conduct that violated the federal antitrust laws. The court held that the association was still liable for their conduct, even though they actually did not have the authority to do what they did, because the association allowed them and didn't take proper precautions to prevent them from acting with that authority. And so that principle still very much holds true today, and perhaps even more so in the social media context. One last question, then we need to wrap up.
So if I can put the three of you in the role as a nonprofit board member, are there any unique or additional concerns or questions you might have regarding social media and our topics of today?
In terms of communications by the board member?
So, if you're a board member, is there anything in particular that you want to be asking that's different than what we've covered, or?
Well, I'll tackle the apparent authority.
Yeah.
I mean, just because you're a board member doesn't mean you're authorized to speak to all activities of nonprofits. So as a first point, I would say that's another area where, as a board member, you need to be thinking about whether or not you're discussing something that you're authorized to speak about. And then Krista can talk a little bit about sort of whether or not the board can ask nonprofit, are you doing everything you need to be doing? So just summarize a little bit there.
Yeah, I mean, I would basically want to ask the question of, what do you plan to use, what are you using, or what do you plan to use on your social media site, and where is it coming from? I would want to get a sense to make sure that you've got the ownership rights locked up, that somebody is aware that there are privacy and publicity rights that the folks who appear in images or content will have. I would want to know that somebody is sort of looking at those things in a methodical way, because more often than not, I think with the speed of social media, some of those things get swept under the rug. So I'd want to see a plan of some sort that sort of lays out where the content's coming from and who's cleared the rights.
Yeah, and then on the flip side, and I know from a lot of personal experiences, I do a lot of this, as do a lot of my colleagues, it's very important as part of your annual board orientation and training that you make clear to them in the social media context and otherwise what their fiduciary responsibilities are as board members, what the limits are in terms of apparent authority, what rights do they have or not have to go out and speak against, say, particular actions that have been decided by a majority of the board. These are really difficult, sticky, but important situations that lead to a lot of strife and controversy in nonprofit organizations, and a lot of it can be avoided, I've found, by good education and training up front. So with that, I want to thank AJ and Krista for a terrific job. Thanks for everyone online for hanging out a bit long today, and everyone here in the room. We hope to see you back here next month for our next program. Thank you.